Okay, let us start. Good evening, brother and sister. My name is Yap. I'm from Labor Law Reform Coalition. Welcome to this series 5 of this LLRC webinar, which with the title Gender Perspective in Labor Law Reform. In the past few series, we actually discussed a lot of this labor law reform from different perspectives. So the first one, we discussed the importance of the unemployment insurance issue. Then we have to deliberate this Employment Act, Trade Union Act, and Industrial Relation Act, and also this fuel law. And today it's very important that in all this discussion on labor law reform, we need to have a women or gender perspective, because many times this discussion is very male dominated. So it's very important we have other angle to look into this issue. And today we are very happy to have this prominent speaker to join this discussion as a panelist. The first speaker will be Shanti Dairiam. She is the former United Nations CEDAW committee member and also vice president of the Women's Act organization, and also the founding director of the International Women's Rights Action Watch Asia Pacific chapter. And another speaker, we have Bina Jaya. She is the lead coordinator for the Malaysian campaign for equal citizenship and co-founder of the Foreign Spouses Support Group. Yeah. So now let us start with this topic. I would like to give the floor to Shanti to present her view on this topic. So she has a PowerPoint. Let me share the PowerPoint first. 1 minute. Okay, Shanti, you can start. Shanti, you need to unmute your mic.
Good evening, everybody, and thank you very much to the Labour Law Reform Coalition for hosting this webinar on gender perspectives in labour law reform. I'd like to start the process straight away. Can we go to the next slide, please, Yapwa? Okay. I'm posing a question here on why look at gender perspectives in law, policy, or programs. It is essential to have a gender perspective. It's essential in the attempts to achieve equality between women and men. That is why we are looking at gender perspectives. Now, all attempts, therefore, to bring in a gender perspective must be based on the principle of equality. It's not just are women addressed, are issues pertaining to women brought into the discussion. It's not just that. It has to lead to the achievement of equality. Achievement of equality is an obligation of the state under CEDAW, a human rights treaty acceded to by Malaysia on July the 5th, 2005. Now, CEDAW sets the standards for all area of rights to equality for women. So I'm going to bring that discussion a little bit first. What are the standards for equality that CEDAW prescribes? Next slide. What are the aims? Yeah, aims and objectives and obligations of the state party to CEDAW. Next slide, please, Yapwa. There are two major obligations under CEDAW. One is the prohibition and elimination of discrimination, not just prohibit, but eliminate. And the second main objective and goal is promote and fulfill substantive equality for women. So both must come together. Next. Okay, setting the standards. I'm looking at women's right to work on the basis of equality, and we are guided by CEDAW Article 11. I'm not going to read the whole article because there's A to F, but basically CEDAW says women have the right to work as an inalienable right of all human beings and the right to the same employment opportunities and the same criteria for selection in matters of employment. Equal remuneration is there, and the right to protection of health and safety, as well as the right to job security and conditions of service. Let's go to the next one. I'm rushing through these standards because I don't want to spend too much time on them. Now, in CEDAW Article 11.2, I've highlighted one important provision, which is C, which is to encourage the provision of the necessary supporting social services to enable parents to combine family obligations with work responsibilities and participation in public life, in particular through promoting the establishment and development of a network of childcare facilities. Among the many things that CEDAW talks about where employment is concerned, including elimination of discrimination on the grounds of pregnancy and the provision of maternity leave and benefits, this 11.2c for me is very important, that there are positive obligations of the state to put in place certain support services so that women can come out to work. And that is Article 11.2c, and that is what I have highlighted. Can we go to the next one? Now, once we have an understanding of what the rights and obligations are of the state, the rights of women and the obligations of the state are, we have to look at how do we operationalize these entitlements to rights. It's not enough to just have it in the law. De jure, yes, there'll be laws for women's right to work must be based on the principle of equality, first of all, but it must be operationalized in every context. Example, the right to work must include inter alia, equal work opportunities, reduction of wage gap by enforcing equal pay for work of equal value, policies for work-life balance, such as flexi hours, availability of part-time work, maternity benefits, and affordable daycare centers. So these rights must be operationalized into policies and programs, and that we have to see whether our laws allow for this or not. Next slide. Now, I just want to look at, I don't know how much I must say about CEDAW. CEDAW sets, first of all, the standards in all its articles, but CEDAW reviews state party compliance with their obligations, and it issues what is called concluding observations to every state that comes before it. And the last appearance of Malaysia to be reviewed by CEDAW was in February 2018. And we have, I picked out one concluding observation, which is paragraph 38C, 2018, and where it speaks about reducing wage gap as an important area of rights for women and an obligation for the government. It said, reduce gender wage gap by regularly reviewing wages in sectors in which women are concentrated and establishing effective monitoring and regulatory mechanisms for employment and recruitment practices to ensure that the principle of equal pay for work of equal value is guaranteed in national legislation and adhered to in all sectors. Our laws prescribe equal pay for equal work. If you're doing the same work, you will be paid the same, and there is no problem there. But women are concentrated in certain jobs in which men do not feature so much, like nursing or kindergarten teaching. And those areas of work may not be valued enough to have wages that will be comparable to an area of work in which men are concentrated. And so this is what we are asked to do, that we must monitor this and put in place regulatory frameworks to ensure that work that women do is valued equally. And we'll talk about this a little bit later as well. So can we go to the next slide? No, I will speak about this later. Next slide, please, Yapwa. Okay, now the second point I want to raise, secondly, is that a purely formal, legal or programmatic approach is not sufficient to achieve women's de facto equality with men, which the committee interprets as substantive equality. What we are saying here is to have equality in the law is not enough, that the state has an obligation to ensure that the right to equality is actually exercised and enjoyed by women. So it's called de facto equality. So it is not enough to legally guarantee women's treatment that is identical to that of women or the same treatment. Now, why is this so? Can we go to the next slide? Now, I am very particular about this because whenever I am in conversation with a lot of other human rights activists, including trade union brothers, they keep on saying that the law is neutral. It says we are all equal. It's not differentiating between women and men. But the story doesn't end there. You can say women and men are equal. The law can be neutral, but there are certain differences between women and men that needs to be taken into consideration in the operationalizing of that equality provision. Now, so what we are saying then is there are biological as well as socially and culturally constructed differences between women and men. Under certain circumstances, non-identical treatment of women and men will be required in order to address such differences. So we cannot treat women and men in the same way. The provisions of the law must provide for differential treatment. This is what is meant by taking a gender perspective. So we must understand what we are talking about when we say a gender perspective. It's not just mentioning women in the law. The aim and obligation is to achieve equality of results and not just to have equality in the law. Now, how do we do that? Can we go to the next slide? Now, there are these results that we are looking for, may be quantitative and or qualitative in nature. That is, women enjoying their rights in all fields. They must be equal in senior positions, in fairly equal numbers with men, enjoying the same income levels, equality in decision making and political influence, and women must enjoy the freedom from violence. All these are indicators of equality and is applicable in the area of employment as well. So we have to see whether our law provides and the Employment Act will facilitate this. Next slide. Now, evidence of lack of equality, therefore, is seen by differential outcome, which is underrepresentation of women in the workforce, underachievement in schools, underrepresentation in policy formulation bodies. This shows there is no equality, even if the law says we are equal, even if the constitution says we are no equal, we are still not equal. Thus, achieving equality of outcome will be a conclusive demonstration that opportunities have been equalized and indeed women are exercising the right to equality. So the law stating men and women are equal, though it is essential, the law must state that, but is nevertheless not an indicator of equality. Next slide. So first step towards equality, what do we do? Discrimination must not only be prohibited, but also be eliminated. That's an important goal of CEDAW as well. Next slide. Now, how do we define discrimination? I'm going through all of this because we need to understand this in order for us to examine the Employment Act. Now, as long as any right is denied, whether there was an intention to do so or not, the situation constitutes discrimination. This is what CEDAW Article 1 says. An example of this would be protective measures such as barring women from night work constitutes discrimination because it denies women the right to choose freely, the right to work under safe conditions, and to enjoy a full range of work experiences. So when we bar women from night work, there are several rights that are denied to them. So when a right is denied, there is discrimination. That is called discrimination. Next slide. So what has to be done? Enabling conditions such as strengthening the law and order situation. Why is it unsafe for women to work at night? There is no law and order. Whose fault is that? Not women's fault. Providing there must be law and order situation must be improved. There must be the provision of transport so that there is which will permit women to access all opportunities for work. Failing to do so and being protective of women constitutes discrimination. If we examine our Employment Act, does it fulfill women's right to equality in the context of night work. It provides them with protection. Don't go out at night. That is protectionism. Protectionism is not equality according to CEDAW standards. There must be the right to work under safe conditions. Okay, next slide. In other words, there is an obligation on the part of the state to ensure that the concept of corrective measures is implemented to help women overcome the effect of past or socially constructed disadvantage that creates disparities between women and men or between groups of women also. We cannot just see the situation as the vulnerability of women or an unavoidable social norm. These norms have to be changed and vulnerabilities of women have to be reduced. Next slide, please. Now, CEDAW therefore acknowledges that laws, policies, and practices can unintentionally have the effect of discriminating against women. First of all, women have biological needs that have to be catered for, which is maternity and pregnancy. Secondly, women have been discriminated against historically and socially. They do not necessarily come into a situation on an equal basis with men. For example, next slide. Women, as because of this historical and social disadvantage that women face, women are disadvantaged. They have less access to resources, less mobility, and less years of experience, etc. This is the result of previous discrimination. Catering for biological needs and compensating for social or historical disadvantage constitutes taking a gender perspective. So there are positive obligations or duties such as policies for work-life balance, catering for biological needs of women, and initiatives which will cater for social and historical disadvantage. And I will give you an example of this, a very good example from Australia. Next slide, please. So in order to do this, that is addressing and catering for the disadvantages women face because of their gender, CEDAW has introduced the principle of what it's called temporary special measures in Article 4.8 of CEDAW that mandates special treatment for women to cater for this social and historical disadvantage. There's an example that I have, which I won't go into now, which was the recruitment of women into the Liberian police force. If I have time later, I will tell you that story. Let's go. This is called substantive equality. Let's go. Now, what are these temporary special measures? It encompasses a wide variety of legislative, executive, administrative, and other regulatory instruments, policies, and practices, such as outreach or support program, such as not hotel, sorry, it is hostel facilities, allocation or reallocation of resources, preferential treatment, preferential rule, targeted recruitment, hiring and promotion, numerical goals connected with timeframes and quota systems. The choice of a particular measure will depend on the context. So there are many things that have to be done, especially in the area of employment, that will help women rise above their disadvantage. And the law must help us in doing that. Now let us look at the Employment Act and gender perspectives, which is equality in context. We have to look at it in context. If we understand rights encapsulated in the principle of equality, discrimination must first be prohibited. We've already said that. Now, there is currently no specific clause in the Employment Act prohibiting discrimination on several grounds, but one can be guided by several other provisions in the Act, or there are other laws that can apply. For example, Article 5 of the Employment Act says we can abide by other pertinent laws that help us prohibit discrimination, or we can be guided by certain provisions of the Employment Act itself, which prohibits certain kinds of treatment of men and women. But there is no specific provision for prohibition of discrimination as it stands, although the proposal for amendments has brought in such a clause. Next slide. Now, the proposed amendment to the Employment Act on prohibition of discrimination says the following: No employer shall discriminate directly or indirectly against employers in respect of employment and occupation on the basis of gender, religion, race, or disabilities, unless such treatment is not possible due to the inherent requirements of the employment. So we are proposing, the trade unions and other human rights organizations, women's groups are proposing that such a clause be, provision be included, which is a good provision. I'm happy about that, especially when it says direct or indirect. But my own sense of a little bit of concern is that whether there is an adequate understanding of what is meant by indirect discrimination. And we'll look at that a little bit. Next, next slide. Yeah, Paul? Next slide, please. Okay, okay, no, previous one. Okay, under circumstances, now what is indirect discrimination? Under circumstances where there is difference and inequality between women and men, same treatment or neutrality, also known as consistency, has no legitimacy if it denies women the exercise of all rights on a basis of equality with men in real terms. Neutral treatment can constitute indirect discrimination when the playing field is not equal. This is a formal, neutrality is a formal model of equality, which does not help when there is already pre-existing inequality. Now, I am going to tell you this story. I hope I'm not going to shoot past my time, which is an example of the retrenchment of women from a steel mill in Australia. And this is a real case. Australia for many years did not had a policy that would not allow women to be employed in a steel mill because they said it's a very masculine job and women won't be able to cope. And they had prohibited women from taking employment in steel mills. Now, after some time, when law on equality was refined in Australia, they said, this is discrimination. We cannot prohibit women from accepting any kind of job. So they said women can come in into steel mills. So a lot of women applied and they got appointed. A few years down the road, the steel industry was not doing well and the steel mills began to retrench. They were downsizing and they started to retrench. Now we all know the principle of in retrenchment, last in, first fired. So they said retrenchment meant all those who were the last people to enter the steel mill or get employment in the steel mill will have to leave. And who had to leave? Women had to leave because they were the last people to be hired. And so this was a neutral policy that was applied. The women filed a case in the Anti-Discrimination Commissioner that this was discrimination because they were the last hired because of a previous discriminatory policy in Australia. So now you cannot treat men and women in the same way because men had the opportunity to join the steel mill long time before them and they didn't have that opportunity. Under examination and investigation of this complaint, the Anti-Discrimination Commissioner found in the favor of the women and said women cannot be retrenched because this policy of last in, first fired cannot be applied neutrally. It is indirect discrimination against them and they were re-employed. And so they had to look at a different way of retrenching. So a differential rule had to be applied. So we have to clearly understand what indirect discrimination means. It's something that we have to get our minds around. But there are models and examples in other jurisdictions that will already progress much more than the situation in which Malaysia finds itself. Next slide. Now, indirect discrimination continued. Indirect discrimination also prevails when services are not provided, which are essential for women, such as the lack of daycare centers or transport for night work that prevent women from accessing work opportunities. Then it is indirect discrimination because the employer didn't provide that. Now, let's look at provisions pertaining to employment of women in the Employment Act, Section 34. It says there, night work and other forms of work considered to be dangerous is prohibited. This is protectionism. I've already mentioned this. The other provision referring to women in the Employment Act is maternity leave is already there for 60 days, but trade unions and human rights groups are requesting 98 days maternity leave, which is very good. Then the other provision that is proposed and which is good is termination of female employee after eligible period or during maternity leave and on the grounds of pregnancy is restricted, and it is considered to be an offense in the proposed amendments. So these are good. Number 2 and number 3 are good provisions, but night work still remains prohibited. Next slide. Now, there are amendments to night work. The provision, as I understand it, and trade union brothers can correct me, the prohibition of night work still remains for women, but there is a proposed amendment generally to night work, which is to amend and say that the law must ensure the safety and health of the employee if there is night work or dangerous work. And the other amendment is for the purpose of subsection 1, an employer, the Ministry of Human Resources amendment or proposal is that an employer may, if requested by the employee, provide transport services from home to workplace and vice versa of the employee. But the trade unions are proposing instead of may to say shall. It's not just an option given to them. It shouldn't be an option given to the employer. If these amendments are accepted by the Ministry of Human Resources, there is no need to prohibit night work for women. So we have to look at that discrepancy that is there. Next amendment, next slide. Now, this is an important area that I want to touch, which is there has to be public policy in the legal framework for decent work for women, work-life balance and maternity function, and this is not provided for in the Employment Act. There first of all has to be a change of mindset regarding roles of women and men in terms of family responsibilities. Now, if women's labor force participation is to be enhanced, they cannot be held solely responsible for care of the family and children. These responsibilities have to be shared by men, by the government, and by other institutions. CEDAW, the preamble to the CEDAW says, maternity is a social function and society must bear the costs, not just women. There is a role for public policy here. Refer to articles, CEDAW Article 11, 2C, which I've mentioned in slide 6. Okay, next slide. Now I'm going to give you a good model for a legal framework touching on gender perspectives in the law for employment, which is what is called the Magna Carta for Women, Philippines, which is based on the principle of equality. The Magna Carta says, laws for women's right to work must be based on the principle of equality. This principle must be operationalized. Example, equal pay for work of equal value and policies for work-life balance. Above all, employment law must protect human rights. Next slide. This is an important, next slide, important. There is a section 22 in the Magna Carta of the Philippines, which says right to decent work for women. The state shall progressively realize and ensure decent work and standards for women that involve the creation of jobs of acceptable quality in conditions of freedom, equity, security, and human dignity. Decent work involves opportunities of work that are productive and fairly remunerative as family living wage, security in the workplace and social protection for families, better prospects for personal development and social integration, freedom for people to express their concerns, organize and participate in the decisions that affect their lives, and equality of opportunity and treatment for all women and men. Next slide. The state, section 22B, is very important. The state shall further ensure support services and gears to protect them from occupational and health hazards, taking into account women's maternal functions. 2, support services that will enable women to balance their family obligations and work responsibilities, including but not limited to the establishment of daycare centers, breastfeeding stations at the workplace, and providing maternity leave pursuant to the labor code and other pertinent laws. So this is already in their law. Now, I won't go too much into this repealing clause. This slide says that that the state has a duty through law and policy and regulatory instruments to administer guidelines and other appropriate measures, etc., etc. Go to the next slide, please. Now, the state shall keep abreast with and be guided by progressive developments in human rights of women under international law and design of policies, laws, and other measures to promote the objective of this act. I very much appreciate this provision because what it is saying is the law cannot be static, that the state must keep abreast of developments in international human rights law and be progressive, make the law progressive accordingly. So we have to keep abreast of developments in other parts of the world and in international law. And so there must be change. Now, I'm going to summary and further gaps in the law. The rights of domestic workers are not adequately provided for under the Employment Act. Domestic workers are 100% women, so it becomes a gender issue. They are referred to as servants and not as workers. This denies them the right conferred on workers under the Act. The principle of equal pay for, number two, the principle of equal pay for work of equal value is not incorporated into the Employment Act. There is a convention, next slide. The principle of equal pay for work of equal value was mooted by ILO in 1951 through ILO Convention 100. Malaysia ratified this convention in 1997, but this has not been incorporated into the Employment Act, and this is a gap. Next slide. Violence against women, such as sexual harassment, still not adequately provided for. Women's groups are asking for a standalone sexual act. There is protectionist attitude in relation to night work, absence of policy on providing for work-life balance, flexi hours, part-time work, affordable daycare centers to benefit both women and men. You know, work-life balance and flexi hours and even daycare centers should benefit the family and both men and women. And this will be an encouragement for men to share family responsibilities, there should be an encouragement for men to share family responsibilities by providing for paternity leave. We still don't have that. Next slide. Now, sexual harassment, I'm giving you a statement from the CEDAW's concluding observation to Malaysia in 2018. It requested Malaysia to adopt a comprehensive law on sexual harassment, which enables complainants to seek redress without the time, cost, and public nature of going to court. So this is something that we have to look at and pursue further. Next slide. There is, now I'm looking at the, I've mentioned the gaps, but I'm now looking at the positive proposed amendments. There's prohibition of discrimination on several grounds, inclusion of indirect discrimination, 98 days maternity leave, all code of conducts to be fully enforced to curb sexual harassment is there as an amendment, a proposed amendment. Next slide. That's it. That's it. So these are the positive amendments that are being proposed. So a clear understanding of what we mean by gender perspectives must be there, that right to equality must underpin all assessment of whether there is a gender perspective or not. Thank you.
Thank you much, Shanti. A very comprehensive this review of the CEDAW and the policy gap in Malaysia's laws. And there are actually some comment in the chat box. Maybe Shanti can look at it first. Okay. But we wouldn't start the Q&A first. We will go to the second speakers. And as you know, Labor Law Reform Coalition consists of 58 trade unions and NGOs. And this includes actually a very special organization that calls the Foreign Spouses Support Group. And the group member actually consists of these foreign spouses of Malaysians in Malaysia. And in many times, we seldom heard about this group. And this group of the member, actually, they face a lot of problem during this COVID-19 pandemic and lockdown. And actually the group leader, Bina, also actively involved in this LLRC activity, and we went to Parliament together to push for labor law reform. And today we are happy to have Bina with us to tell us what is the problem, difficulty facing foreign spouses in Malaysia, and how to reform the law to make it better for the benefit of the foreign spouses of Malaysian. So Bina, you have the floor.
Thank you so much, yeah. And I hope it's clear. Is it clear, the audio?
Yes, we can hear you.
Thank you. So a huge shout out to the Labour Law Reform Coalition for giving us this platform to discuss the gender perspective on labour reform in Malaysia. I'm really honored and privileged to actually be on the same panel as Ms. Shanti Dairiam. She's a gender equality expert. I have learned a lot from her. And she's also a member of the CEDAW committee. So it's really an honor and a privilege to be on this same panel as Ms. Shanti. In fact, my first training as a women's rights activist was a CEDAW training led by Shanti. And this was, I think, in the year 2009. And she was training us on how to report for the CEDAW alternative report. Now, to give you some background about foreign spouses, how it started was I myself am a foreign spouse, and I didn't think it should be so difficult for any woman to be bringing up her children in another country. And it was difficult, like I couldn't even take my child to hospital and admit my child who was going through an asthmatic attack. My husband had to be present to admit her into hospital. And I thought this is like, it could be life-threatening and it really should not happen to any mother. So I started talking about the issues, and it was day-to-day a challenge. Opening a bank account is an issue. Withdrawing your own money is an issue. It was like really, really tough. We had to pay double charges to deliver our Malaysian babies as well. So I started this campaign, not as thinking it's going to be big. I wanted to help a few other women in the same situation like me. And so I wrote out my story and I used to read it everywhere I went and told people, if you come across a foreign spouse, please employ them, because, you know, we are all qualified and we are, you know, it's very difficult for us, A, to get jobs, and B, to be the government at that point of time when I came in the 90s, they did not allow us to even work. We were just on a dependence pass. So I couldn't, I didn't want to be vulnerable. A, I don't have support systems in this country. I decided I needed to have financial autonomy. And so I forgot about my spouse visa. I went on a work permit. But what I didn't know is for those years that I went on a work permit did not make me eligible for PR. And without a PR, it also means that you cannot live in this country if anything were to happen to your husband or to your marriage, even though your children are Malaysian. So with that little background, I said, okay, let me at least help a few other women. And so I met Asha, and together we went to WAO. And this was way back in 2009. And we started a small group of us, started Foreign Spouse Support Group to help other spouses. And that's when I started also training myself, because I didn't have any training. And the first training, as you know, was the training, CEDAW training by Shanti. And we attended a few other trainings. And with that, my first submission was actually in the 2012 CEDAW report, where I actually was able to talk about the marginalization and the discrimination faced by foreign spouses. So this is a little bit of the background, but I'm now going to focus on the restrictive rights to employment, its disproportionate impact on women and children, and we'll go on to do some recommendations. And Shanti, thank you so much, because you laid such a wonderful ground on CEDAW and women's rights and why is it necessary in the country. So what are these restricted rights to employment is, even though there are about 150,000 visas that are issued to foreign spouses in Malaysia. So that means that there could be at least close to 200 to 250,000 spouses who are on the long-term social visit pass. But our visas come with a statement which says any form of employment is strictly prohibited. Imagine you're married to a Malaysian, you have Malaysian children, and your visa says any form of employment is strictly prohibited. And any employer who sees this would at the first instance tell you, hey, I'm not going to take you. He's going to be really worried. He'll say it's a risk for you to work, for me to take you. So although and then immigration goes on to say that, oh, you can be employed with a permission to work from the immigration, which is like a small chop in your passport, which allows you to work for only that employer for the duration of your visa, and only in the same state as where you reside. Now, everybody knows that, you know, jobs are so hard to come by as well. And if you're residing in Selangor, it shouldn't be difficult. A lot of people also work in maybe KL or in Seremban. There are people who come from Malacca working in KL. But this, they don't allow foreign spouses. And also another thing is we are at the mercy of the immigration department. So a lot of the women are skilled with, you know, they would like to work in nail spa, or some of them singers. They're not allowed to work as a singer in maybe a club or in the wellness industry, because these are all termed as illegal. So you are actually dependent on the mercy, I mean, on the compassion of officer, each attending officer. Also, they come up with these new rules now and again that, oh, foreign spouses cannot work in recruitment agencies. Okay, so previously you have a lot of IT countries which are an outsourcing companies. So if a company outsources their payroll to another company, a spouse cannot work in that company. And so we are also dependent on these rules, which are very arbitrary. And these rules have all, I think, evolved in the previous century even. So it also means that those who are working on projects will not even get a spousal visa. If you're working on overseas, you cannot get a spousal visa. If you are working freelance jobs, you cannot get an endorsement to work. Or if you're working remotely in Malaysia for a company overseas, that is also not allowed. So in April, we kind of got worried because of the pandemic. As we all know, the first people to be let go is a foreigner. So we took out a small survey of about, and we just posted this survey for less than a week. 250 spouses responded. 50% of them did not have the endorsement to work. And why is that? Because it's so difficult. The remaining were either not working or on a professional pass or working in the informal sector. At one time, and one of the things we do at FSSG is we actually have an FB page that has about 20,000 people on that page. Now, over the years, we collected 20,000 people. But and we answer queries. We really respond to queries. And one of the men who was a foreign husband who was here for 10 years, did not know that he could get permission to work from immigration. Of course, the permission to work comes with a lot of conditions, like you need an offer letter from a company, you need to show the payroll of the company, you need to also show the forms, who are the directors in the company, and the licenses. This man was so happy, and I was wondering, for 10 years, we took him to find out that that as a foreign spouse, he could work. So, and a lot of women as well are not aware that they can work, because, you know, on your visa, it says prohibited from employment. So many of them are just maybe quite qualified, but are staying at home. So from this survey, we also found out that 56% of the spouses who were working prior to the MCO. However, once the MCO started, only 26% of them still had their jobs. That means more than, a little more than half of them only had their jobs. So less than half have lost their jobs. So the first people to be let go in an organization are foreigners. And we are spouses, but we have a Malaysian wife. Some of them have Malaysian wives, Malaysian children. And 74% of the 250 spouses who responded actually indicated they experience challenges to employment. They are serious challenges, because employers just see the prohibition statement, they don't want to take you. And a lot of them resort to working in the informal sector. So which means when you're in the informal sector, you lose out all the protections. 50% of the spouses also face difficulty in opening a bank account. I really don't understand why it should be so. You know, a bank account, I've had a bank account from the time I was 8 years old. And when I came to Malaysia and I was told that I cannot open a bank account, it shocked me. How can I come into another country and without my family members, nobody around me, I only know my husband here, and they asked me to open a joint account? I was like shocked. As a woman, I felt I really needed financial independence. I need autonomy. I need to decide about my finances myself. I'm not going to have a joint account. And it took me a few calls even to Bank Negara, but I'm a fighter, so you can see it, to actually ask them to allow me to ask the bank manager to allow me to open an account. Okay, I said, do you want me to put the money I have brought from my country under the pillow? So that's the kind of thing you have to face on a almost daily basis. Even up to, like, if you go to a theme park, you just don't get a normal rate. You have to pay a tourist rate. But we are not tourists. We've been living in this country for so many years. And then comes to the lack of social protection. While we can work in the country, employers do not want to give EPF, but they deduct your EPF. We are here for the long haul. We are part of the Malaysian family. And most of us know that how useful the EPF is. When your children grow up, it can pay for their college a bit. You can pay for housing, and it pays for your retirement. I think at the end, when I turned to 50, what I had was actually only my EPF savings. And that is what a lot of Malaysians also have. But if you don't even have that, what would a woman have? What is she going to have if she does not even have her EPF? And SOCSO, which just started, I think 2 years ago, we received social protection for employment-related injury, but as non-Malaysians, we are not entitled to any invalidity pension scheme. And when a spouse first gets married, especially a foreign husband, they experience forced, and I call this state-enforced unemployment. Because for a period of 1 year to 18 months, during a foreign husband's early marriage, he is not allowed to work. And how is that happen? So if they are a migrant worker, he has to leave his job, leave the country, and spend 6 months in his home country. He comes back, gets married. Next 6 months, he does not get any visa. to live in this country. I mean, who in their right mind, you've just been married and you want to separate the couple. And then when they come back, he gets a 6 months visa without the right to work. 18 months, no job. So who is the foreign husband dependent on? It will be the Malaysian wife. And what happens if the Malaysian wife is unwell or she's a homemaker? So, but these are the laws. These are the laws. And they are ad hoc laws. They just made, I think when it's like a knee-jerk, sometimes it's a knee-jerk reaction. So suddenly once KL immigration way back in 2017 decided that women should not work for the first 3 years of their marriage. And we really were so upset with this rule. How can you, and we told them it goes against CEDAW. Finally, we had to speak to MPs. By that time, the new government came in and we were able to overturn this, this law, this policy. It's not a law, it was a policy. And I sometimes think that, you know, this discrimination against women, immigration either it chooses to ignore because Malaysia is a signatory, but do they really follow? And the long duration without permanent residence keeps a woman in bounded to the husband. So until you get PR, you are dependent for your legal status in the country. Until you have PR, if you're working in the banking sector, in finance, in law, or if you're one of those professions that require a license, you cannot work until you get PR. And when does PR come? To me, it came 18 years after my marriage. My prime time was over. Even to drive a goods delivery vehicle, you need to have a permanent residence. Imagine. So what option do these, even though it's a man who needs to, I mean, the man is working, if the man is not working, it puts such a tremendous burden on the woman. They cannot even become a Grab driver until you get PR. To drive a, you know, Grab, you need a permanent residence. And it's putting a strain even for the foreign woman. There's so many jobs that she cannot secure. And this is a discrimination. And what about, how does this impact women? That is the Malaysian woman who's married to a foreign husband and a foreign woman who's married to a Malaysian husband. And there are different laws. There are really a lot of differences. One is non-citizen spouses just were very qualified and many of them have to stay at home. These are lawyers. I have friends who had LLB degrees but could not practice because they don't have PR. The income of the family is largely reduced due to these restrictions. Sometimes we have many cases where the foreign husband has a PhD and he called me once and he said, please tell me, where should I commit suicide? Would you think will get more attention? And I was shocked. I said, you have a PhD. He said, tell me, should I go to Putrajaya or Jalan Duta? Because these are the immigration places we all frequent. It took hours of talking to and asking him to go to the counselor in his university, you know, and speaking to the wife before we could, you know, make him overcome that. And this is not one case. There have been many cases like that where the men are actually go through depression, and then the entire responsibility falls on the woman. So in these kind of situations, there's an unfair burden on the Malaysian wife if her husband is not able to secure employment. It's also not in the best interest of the child. Malaysia is again a signatory of CEDAW. It's a signatory of CRC. And it's not even helping the child. If you have a prohibition statement and the husband and the father cannot work, or the mother cannot work, then the child, it's not giving the child the best life it deserves. And also, when you have these kind of restrictions, a lot of the women turn to informal sector, where, you know, there's no contract, where they tend to get even sexually abused. We've heard of cases being sexually abused at the workplace. Why is that happening? Because they are working in the informal sector. And then they also, when they work in the informal sector, they don't get any of the benefits. They don't get health benefits. When they have workplace injuries, they just be terminated like that. So I will tell you that the other thing that has happened in the recent years is because of this difficulty in securing employment, and also the low compensation of salary package for non-citizens. Many of the spouses sought jobs overseas. So some of it, they work, they are working across transnational borders. So either the wife stays here, the husband goes there overseas, or the woman goes overseas, and they are separated from their children sometimes. And in some cases, there's forced migration. The woman goes to the other country because she's forced to. There's no choice for her. So these are some of the difficulties of women face and how they are impacted. So this, in 2018, the CEDAW committee raised their concern that foreign women who are married to Malaysian men are dependent on their husbands. And I'm reading to you directly from what was written. Okay, the committee was concerned that foreign women who are married to Malaysian men are dependent on their husbands to maintain their legal status in the country, which places them in a situation of vulnerability, particularly in cases of domestic violence. It also notes with concern that foreign wives with long-term social visit passes are prohibited from engaging in any form of employment, which creates further dependence on their husbands. Until today, when we ask the Ministry of Women, everything when they are questioned, they will say, oh, this is something for Home Ministry. This comes under the purview of Home Ministry. But we are women. We come under the Women's Ministry. And therefore, they should take ownership and try to make some changes. If we look at the number of migrants in Malaysia, there are about 156,000 spouses on the spouse visa. And I'm just giving you the yearly figure, which I got from the immigration website today. 150,000 are on expat visas. That means there's a need for professionals in the country. 2.1 million, these are 2019 figures, 2.1 million migrant workers. So you also need skilled people. And these are the documented workers. So if Malaysia is a receiving country where there's a requirement for professionals and skilled and unskilled workers, the government should also give consideration to foreign spouses who are in Malaysian families, so that they can reside in the country. And also it benefits the country because these people will be paying tax. They are staying together as a family. Money earned in Malaysia is going to be spent here on property, on the welfare of the Malaysian family. Now, COVID actually brought out so many issues which we really did not know. I mean, it was something that we ourselves who've been working for 12 years, I've been working on the issue since 2009. And it's until today, it is difficult for me to really just close my eyes and have a good 8 hours of sleep, because I'm just thinking, who is in a difficult situation? So the pandemic actually really heightened the vulnerability of women, because many of the men were working overseas, and those who are working overseas do not get a spouse visa. So they are stranded outside the country. Okay. And the women are here, pregnant. Some of them are pregnant with young children. And they desperately wanted their husbands to be here because it's a pandemic. There's fear. And what happens? Malaysia is allowing other categories. We couldn't believe it. We were just amazed that they were allowing Malaysia, my second home, people to come in. They were allowing professionals to come in. There were migrant workers who were also coming in, some of them. There was also expat spouses and their domestic workers who are allowed to come in, but not spouses. And it was shocking to us because there are children who are crying for their mothers, for their fathers, for their mothers. There are mothers overseas. So we have these cases of few of the Filipino mothers who went to renew their passports. Would you believe it? They just went to renew their passport and they can't come back in. They are stuck there from January this year. Some are stuck from February this year. And their children are here. A mother separated from her child. Do we have an excuse for that? There are fathers. And this man who told us, my wife has cancer, allow me to come in and take care of my wife. There are women who said, I'm pregnant, I'm 8 months pregnant. If I'm going to deliver, who is going to drive me to the hospital? And I have 2 children who are 5 years and 3 years old. And these were the kind of difficulties women were facing. They were taking care of older people. Some were totally mentally depressed. There was a lady who said, my husband is supposed to be here. He was working here. And he just went out to see his old mother. His mother was aged. He went overseas and he's stuck over there. The landlord is coming to my house every 3 days. Should I jump off the building? What should I do? And there's nowhere we can go. We tried to get meetings with immigration. We tried to explain. We did data collection, surveys where we got in and we segregated. We had 77 women who were pregnant and their spouses are overseas, or women who are overseas and pregnant and cannot come into the country. Do you know what happens to a Malaysian woman who's overseas and has a baby there? Her child does not get Malaysian citizenship. Why? Because she's not a Malaysian man. If it was a Malaysian man, he can easily get citizenship for his child within 3 days. So the heavily pregnant Malaysian woman has to come back to Malaysia to deliver her child in order to get citizenship. And this is the unequal laws for citizenship. And we had layers and layers and layers of problems. Even, I hope I'm not getting you all depressed, but this was how it was day in and day out. We had men who, the wife would call me and say, my husband's visa is going to expire. If he goes back to India, where the COVID is rampant, he's in a banned country, he cannot come back into Malaysia. Right now, 6 months have gone by. 106,000 people came back till the end of August of different categories: Malaysia, my second home, medical tourists, international students, all who didn't have relatives, immediate family members in Malaysia. Yet spouses were not allowed to come. Today, there are 23 banned countries. Most of the spouses are from these countries. Today, the quarantine charges are doubled. One of the spouses who saved up 40,000 for her postgraduate studies paid that for her family to come into the country. So if a spouse, if they come in, the quarantine charges are now doubled. Some of the mothers have just said, I can't afford to come. I just can't afford to come. I'll just wait till whenever they lift up the quarantine. So this is what they're going in. And what happens to the women? Many of the women are facing isolation, depression. They have given birth without their husbands. And just because they are working, their spouses are working overseas. Even registration of the child's birth in Malaysia, they are not even given equal rights and guardianship, because they are not allowed to register the birth of the child, and their spouses are overseas. They can't renew their spousal visas as well. In certain things, immigration has said, okay, you can, during this RMCO, they don't, what did they say? It is not considered as an overstay if you do not get your visas renewed. But what we saw, what happened, right? Those cases of Indian tourists who could not renew their visas, they went into detention. So we don't know what kind of situation is going to take place.
Yeah, Bina.
Okay, I'm winding up with my recommendations.
Yes, thank you.
So now we just come to the tail end. So actually we are saying it benefits the government of Malaysia if they to allow foreign spouses who are professional, just to allow foreign spouses to come in, because there are so many different categories of them. It's a good opportunity to mobilize talent back into the country, because we're always crying that there's a brain drain. Why don't we reverse the brain drain? Allow spouses to come in. And then also to make the bureaucratic procedures a bit more easier, to facilitate professionals and other skilled spouses to enter the country. Okay, and to remove the restrictions and limitations on employment, because it hinders the sustainable livelihood and for the Malaysian family. And the main thing is we want the prohibition from employment statement to be removed. And the permanent residence applications to be approved, which is not being done, because money earned in Malaysia is going to benefit the family and also the country when the spouses pay tax. And thank you everyone for listening.
Thank you very much, Bina. We know there are a lot of the issue facing this, a lot of problem facing the foreign spouses, and not only the employment, there are also the citizenship and the right to own this bank account and the other issue. Yes, so thank you very much for Foreign Spouses Support Group for fighting for this issue. This is a very important issue. Now we enter the Q&A section. I think in the chat box, there are a few questions posed to the speaker. I think one of the questions by Alice Chang. Alice Chang asked the question, why does this proposed amendment only touch on the sexual harassment but not applicable to bullying, third-party harassment, for example, violence from the customer and domestic violence? Any of you or Shanti want to try to answer these questions?
Yeah. We are only looking at provisions for sexual harassment in the Employment Act. The whole area of violence against women, including whether it's bullying or whether it is domestic violence, it doesn't come under the Employment Act as such. Sexual harassment itself, what is being proposed by women's groups is a standalone law on sexual harassment, which looks at harassment in every context, not just in the context of employment and workplace harassment. For domestic violence, there is a good law on domestic violence. It touches not just, it doesn't come into the workplace context at all. The other forms of violence against women, the other thing that women's groups are also proposing is legal provisions to address stalking and cyberbullying. So there are proposals for all of this, but when we look only at the Employment Act, we are looking at workplace context. And there we definitely need to look at different contexts, varying contexts within the workplace also, where it's not between employer and employee only, but where you can have contractors and other third-party individuals involved in some kind of workplace contracts that needs to be looked at, but it is still not adequate. Whatever is there in the law is not adequate, and we have to make violence against women and all forms more comprehensive in the law. I agree with you.
Yeah, thank you very much, Shanti. So I don't see any more questions. If the participants, you have any question, you can just post your question in the chat box, or you can also unmute your mic to speak, to tell the question. In the meantime, I would like to post one question to Shanti, one question to Bina. Can Shanti, you further elaborate what does it mean equality of the result in the employment issue? Does it mean, for example, if a woman work as the sales manager and another woman work as the factory workers, they should enjoy the equal salary if they work 8 hours a day? Or what does it mean? And how the policy, how the laws can regulate this kind of the equality of result?
See, equality of results is a principle under CEDAW, which says that when there is a provision for equality, for example, if it says there should be no wage gap, and there should be equality in wages, we can't then say from top to bottom everybody should have the same salary. But we should look at categories of work and whether men and women enjoy the same wages in that category of work. So if it is, for example, and those categories have to be very carefully assessed. For example, you look at, I've given this example in equal pay for work of equal value as well. When you look at, say, plantation workers, you have plantation workers working in the area of rubber tapping, and you have plantation workers working as palm oil harvesters. And invariably, they are, there's a difference in gender. Men are working as harvesters of the palm oil because they are huge bunches and requires physical strength. But in the rubber plantations, you have tappers who are largely women because they have to tap rubber, the bark, slice the bark. Now you can ask for equal wages in that category. So you have to categorize same level of skill or whatever. So if you value physical strength more than you value skill of tapping rubber, then you pay the male more because you say it requires physical labor. Then you don't have equality of results there, although your law says men and women, there should be no wage gap. There should be equality in wages. You can't have that. So you have to make sure that there is equality in results there. Another example is labor force participation. There's equality in access to work. Everybody has the right to access to work. We're all equal there. But if you do not provide support services for women, for childcare, and so women drop out of the labor force and do not come back to work after childbirth, there is no equality of results there. They are not there in equal numbers in employment. So when you say the women and men must have equal opportunity to work, that is in the law or in the policy maybe. But if you look at the result, less women are in the workforce. So you have to identify whether there is equality in the actual enjoyment of that right. That is what we are talking about. Actually, we need a lot more time and we need to work with case studies to clearly understand these principles. My concern has been, and I've said this at other meetings, all of this comes from obligations under the CEDAW as a treaty. We ratified it in 2005, and it is 25 years since we ratified. But the knowledge of CEDAW and what CEDAW is saying is not known, neither in government circles, in human rights activist circles, and even among some women's groups. We have not managed to understand what this treaty is telling us and what the obligations under this treaty is. Even at trade union meetings, I have found trade unionists had no clue what I was talking about when I talked about CEDAW. So this is a legally binding instrument, and we all don't know much about it. And we need to learn about it. That is the problem. I don't know if I'm giving you an adequate answer for equality of results. When a right is given, you must be able to exercise it, and not just in the law says you're equal, so you're equal. You're not equal because the law says you're equal.
Yeah, thank you. I understand. So the principle is actually to close the wage gap in the same industry. It's actually focused on the male and female, the gender equality.
Yapwa, if you will allow me, I remember earlier that I had a little note which said I wanted to talk about the Liberian police recruitment in the Liberian police recruitment case. That will tell you about equality of results. When Liberia came out of civil war, the African country came out of civil war, more than 10 years of civil war, the UN administered Liberia for some time to set things right. And they had to refocus and reinstitute every institution of administration and governments, including police force. They had to create a police force. So the UN advertised and said, anybody who is interested in joining the police force, you have to be of a certain age, which was fine. Please apply to join the police force, but you must have 6 years of formal education. Then you apply. Now, when the applications came in, and I was there in Liberia when I saw this personally, applications came in, not a single young girl applied, because this was for youngsters. You had to be below the age of 21 or 22 or something like that. 10 years of civil war, these 21-year-olds were hardly 10 or 11 years when the war started. Only male applied to join the police force because they had 6 years of primary education, a formal schooling. Not a single girl applied. So there is no equality of results, although the law, they brought in the law which said you're all equal, you'll have equal right to employment. But women didn't have the result. They couldn't join the police force. Why? When the war started and was going on, many of the young boys fled the country. They went to neighboring countries and they acquired some sort of education when they ran away like that. But the girls were all 10 years old, 11 years old, 12 years old, were captured by various army factions, because it was civil war, so there were many different factions. They captured them and kept these girls in their army camps as army wives and sex slaves. So these girls cooked and cleaned for the soldiers and provided sexual services for the soldiers. When the war ended, none of these girls had an opportunity to get any kind of education. So this is what is meant by their historical disadvantage. They had a historical disadvantage. Now, how do you create equality of results then? What the UN did was it re-advertised and didn't put that criteria of 6 years of education. They said, if you're interested, apply. 300 girls applied without that criteria of, when you didn't ask for that criteria of 6 years of education. What the UN then did is, why did they ask for 6 years of education? Literacy, reading, writing, and arithmetic. They needed to count, write, and spell. So you didn't need to go to school for 6 years to learn that. So they then set up 6 months of intensive reading and writing and arithmetic for the girls who applied. Out of the 300, almost 200 qualified after 6 months. And then they went through various tests and so on. And or more than 50% of those girls got recruited into the police force because they were literate after that. So you have to have, CEDAW says, find out what is the gender issue here. Why did girls not apply? And compensate for it. Invest in them and give them an additional training and a qualification and bring them into the workforce. And then you created equality of results. More than 50% of the girls who wanted to become policemen became police force, got into the police force through that extra, what is called temporary special measure. You need to do that. And that is there in CEDAW, Article 4.1. So then you must do an additional program to bring about equality of results when there is already pre-existing disadvantage for a certain group of people. This can happen with indigenous people. It can happen with not just gender. And poverty, plantation workers here in this country, youngsters from plantation sector have a lot of disadvantage. They cannot get into the mainstream. So you have to find out what is that disadvantage and have a program to help them overcome that disadvantage. Invest more in them.
Thank you.
Additional measure.
Thank you, Shanti. I think this case study actually shows how important to have a gender analysis in any of the
you must analyze what is the gender perspective here.
Yeah.
So we must understand what is gender perspective first of all. Although we use the words gender perspective very loosely.
Okay, Shanti, I just want to add something. Just now, in your presentation, you talk about the 9 works. Actually, in the Ministry of the Human Resource proposal, the ministry actually proposed to remove the prohibition of the women to work at night. So that is a good proposal by the government side. And so if the law is enacted, then in the future women can work at night. But in another provision talking about the transportation and this deck,
yes.
That was the proposal from our trade unionist Bruno.
Yes,
I think Bruno added that we must provide the transport for the men and women to ensure the safety and health. Because not only the safety, they must ensure a healthier workplace environment at night. So this is just a little bit addition.
You're right. No, you're right. Yep, well, let me just say that rights are never singular. They are always interrelated. You have the right to work and to a range of work experiences like night work. That is a right. And a right to choice. That's a right. But all of these rights must come along with right to safe conditions of work. So right to safety is part of the right to work as well, and right to safe conditions of work. So just removing the prohibition from night work, that will not necessarily mean that women will all jump up and go for night work, because they may still feel that they are not safe coming out to work at night. So this proposal from the trade union that you must have safety provision of transportation, which shall be given, must also come in at the same time. So you can remove the prohibition from night work if you also bring in the safe conditions of work. I know of a place in India which what they did was they didn't provide, because the work would end at 3 o'clock in the morning, and they didn't provide transport at 3 o'clock to go home, but they provided a kind of dormitory facilities. So after 3 o'clock, when you finished your night shift, people could sleep in the workplace, in the dormitories, until early morning when it was daybreak, and then they could go home. So there are different ways of catering for that need, so that there is safety. So right to safety is equally important.
Okay, yeah, I think that is the concept of this substantive equality. We need to correct environment, the policy that is a disadvantage women and the vulnerable group.
Very good.
Yeah.
You got it.
Yeah, I think just now Mr. Mori raised the hand, want to speak, but I see he is not in the meeting room now. but he left a message. Thank you, Shanti and Bina. This was really great in your meeting. We learned from you. Okay. If there's no more question, then I pose the question to Bina. Actually, when you say about the immigration department, they put a stamp on the passport of the foreign spouses that they not allowed to work. Is that under the law? Which law actually prohibit the foreign spouses to work? Actually, because in the Employment Act, there is actually a provision talking about the foreign employee. So with the Ministry of Human Resources, the new proposal, in the future, a foreign employee can apply to the Director General. So if the Director General approve it, then they can work. So my question is whether the ministry's the measure to put a stamp on the passport, is it legal or just yeah?
It is actually not a stamp. It is printed on the visa itself, and every spouse gets this on their visa, which says prohibited from employment, spouse of a Malaysian citizen. So it's probably not in the act, but it's like some kind of policy and directive that they may have at immigration. And yeah, so that's what we think it could be. And then because they say you can work, then you have to go back to immigration with your job offer letter, and they will strike off that prohibition and put a chop which says permitted to work for this company, spouse of so and so. Yeah, so the spouse's name is written on the employment, the endorsement to work, which company you are in, and for the duration. Yeah. So we have to, I guess, find out from somewhere under whether it's a directive that, is under immigration.
So as long as the wording on the visa is not there, then this will remove the obstacle to apply for the job for the foreign spouses.
Only for that particular, that means you go back to, it's not like a blanket ability to work in any organization. So it is only specific to one particular organization for the validity of your visa, and as long as you are married to your spouse. Yeah, so all this, the names of the employer, the name of your spouse, and the duration of your visa, and the place is all mentioned on, it's a stamp, it's a chop on your passport by immigration.
Okay, understand. Yeah, so any more questions from the floor? Questions or comment?
Oops.
Yeah, just now, I think Shanti also touched on the issue that many of the trade unionists don't have an idea what is the CEDAW. I just wonder, because just like when Shanti talked about we push for the maternity leave for 98 days, that is actually under the ILO Convention 183 that requires the state provide 14 weeks of the maternity leave. So I just wonder, sometime maybe is it because the United Nations and ILO, they don't talk to each other? Maybe there could be some kind of the cooperation between the ILO and also the United Nations bodies, so they can work together to push for the gender equality and also this women rights in the trade union circle. Or I just thinking aloud how to create or promote awareness in the trade unions community about the women's right. or WAO can actually provide some kind of the seminar to invite trade unionists to attend.
Yep, just to very quickly respond to that. See, the CEDAW is broader. It gives you a various range of rights. It says that you have the right to work on a basis of, and it says on a basis of equality. But its strength is that it says rights have to be provided on the basis of equality and non-discrimination. But it doesn't give you too many details. In the area of work, for example, the ILO conventions have a lot more content of what those rights are. So like even maternity benefits and all that. Whereas under CEDAW, it will say that adequate maternity benefits must be provided. It doesn't say quantum and how much and under what conditions and all, it doesn't say. However, there is one article in CEDAW, which is seldom used even by women's groups who are aware of CEDAW, which says that if the state party concerned has ratified any other convention or of any other UN body like ILO, or if it has any other domestic law which provides for, has more clarity on what the content of rights can be, then that must apply. CEDAW says that. So when a government goes to report to CEDAW and it comes to the area of work, which is Article 11 of CEDAW, invariably the CEDAW will ask the government about the various, especially the most critical ILO conventions. They will ask them, have you ratified ILO convention X, Y, and Z on maternity protection, on non-discrimination, etc., etc. And how are you implementing those conventions? Are you reporting regularly to ILO? So the CEDAW convention and the CEDAW committee keeps bringing in these other treaties that have been ratified by various governments. I do not think that even ILO talks so much about CEDAW, however. So the reverse doesn't seem to happen. But you're right, I think they should all combine their efforts and see how best to work in synergy with each other. For example, CEDAW committee keeps doing that. It not only talks about ILO conventions to the state parties, it also talks about SDGs and asking them how they're implementing the various sustainable development goals, because they must all come together and use CEDAW as a framework. But content-wise, you can go to the other obligations of other UN agencies. You must bring them all together. They are not separate. You cannot use them as two separate things. So this is something we have to learn to do also.
Yeah. Maybe we can create some kind of this CEDAW this ILO convention joint network to see how to work together to.
I would propose that. That would be a good idea. I'll support.
Yeah, Jack and LLRC maybe can work together on this issue. Yeah, I think. And any other organization, I think is welcome. Okay, I think if there's no more questions, maybe I would like to invite Bina and also Shanti to add the final words. Any comment you want to add? Bina, you have anything to add?
No, I just want to say thank you for this opportunity, and we hope we can all work together. I'm glad that, you know, groups like Foreign Spouse Support Group, we are a small group, and we are so specialized. So we don't come either migrant organizations kind of leave us out. Refugee organizations don't think we belong there. Malaysians don't think we belong there with them. So we kind of secluded, left out, and feel excluded. But LLRM has actually got us, this coalition gives us an opportunity to come together and know that we are supported, because the labor reforms included foreign spouses. So thank you very much for that. And we really need organizations such as us, we need to be a part of this bigger coalition, and so that we can, our voices also can be heard. So thank you for this opportunity.
Thank you also, Bina. Shanti, you have anything on the end?
No, just to again thank the Labour Law Reform Coalition for organizing this session and for asking me to speak. Thank you very much. I think it's been useful, and I want to say, and I support your proposition that ILO, CEDAW can come together. They are not contradictory. They can very easily come together and work in harmony. And we should try and do that. I just want to say one word of appreciation to Bina as well, who has been literally a warrior in this field of rights for foreign spouses. And she fights sometimes a very lone battle and a very hard battle. It seems to, it's terribly disquieting that you see all kinds of expatriates coming into the country, recruited by various organizations. I know my own relatives have come in like that from other parts of the world very easily, and getting even permanent residence on the basis of what they call talent, when there are spouses here of Malaysian citizens who have the talent, but who are completely sidelined and kept out. And I can't understand the logic of that. It must be some kind of political maneuver to discourage Malaysians from marrying outside the country, maybe. I don't know what it is. It is a very strange situation, and it is definitely very violative of human rights of these individuals, both male and female, and women suffer a great deal in this, much more, I feel. And so I really have to appreciate the tenacity and the courage of Bina, who's been at this for a very, very long time. So thank you, Bina, for this great work that you're doing.
Thank you, Shanti. We've had good leaders such as yourself, and it's like great role models for us to look up to and benchmark. We can never reach there, but really thank you for this opportunity. You've trained us. I know when I've called you at different parts of the day, you've always had time to tell us more about CEDAW and women's rights. So I owe a lot to you, Shanti. Thank you.
Thank you. Not to mention.
Yeah. So thank you very much, Shanti and Bina. A very good discussion today. I think if we just a very brief conclusion. If we recall the spirit of the Universal Declaration of the Human Rights, right to work is supposed to be enjoyed by everyone, whether you are the men, women, foreign spouses, or even non-citizens. You have the right to work, to earn a decent income, to have a decent livelihood. So any obstacle to this right to work actually should be removed, and especially in the issue of the gender inequality in every part of the world. We need to use the principle of this substantive equality to correct this so-called historical and socially past mistakes. And any of this work-related issue, we should apply this gender mainstreaming policy to have the gender analysis and try to correct the issue and to ensure to actually cross the gap between the male and female in terms of the wages, working condition, and the other benefits. So this is not the end of the LLRC webinar. I hope everyone will stay online and join our next webinar in next week. This is a weekly webinar. Our Series 6 webinar will be, I think, on 20th October next week at 8 p.m. same time. You can join through Zoom or our Facebook Live. The next week, the topic will be the refugees and also migrant workers' right to work. So please continue to follow us. Thank you very much for joining today's meeting. Thank you. Bye-bye.